be seated. All right, well, good afternoon. Let's get on the record, please. Thank you. We are now on the record. Stop. Okay. Only on your computer. I'm moving around. No, I disappeared.
Well, she shut you off.
Okay, good to go. Let's try this again. Can you hear Can you hear me, Ms. Beatty, Mr. Nye?
Yes,
Yes, Ms. Masseth?
yes.
Okay, excellent. Okay, we are now on the record. This is State of Idaho versus Bryan Kohberger, CR 2922-2805. Mr. Kohberger is in the court with counsel, Mr. Logsdon and Ms. Taylor. Ms. Masseth is participating or observing from Zoom or through Zoom. The state is represented by Mr. Thompson and Mr. Rudley. Also, who are in the courtroom, and Mr. Nye and Ms. Beatty are observing through Zoom. We also have Ms. Olson and Mr. Carone representing the Media Coalition, and Ms. Towler is the court reporter. So, welcome back, everybody. And I think what we need to do is first address the motion to intervene. So, Ms. Olson, is that for you? Okay.
It is, Your Honor.
Thank you.
Your Honor, as with the motion that proposed interveners filed before the court, we seek to intervene for the limited purpose of opposing the defendant's motion to remove cameras from the courtroom. It's our position that the proposed interveners are the ones who are most affected by that particular motion. And in light of the court having asked us, essentially the same group of interveners, to weigh in on this issue before, we would seek to intervene again just for that limited purpose of opposing removing cameras from the courtroom, Your Honor. And I think it's within the court's discretion to do so.
All right, thank you. So, I see this, oh, don't go away. No, I want to talk to you about this, because I think that, well, I'm not sure, okay, that this is the same intervention as we had the first round. I think this is a different situation. And I think some of your clients kind of jumped the gun a little bit, thinking that they are interventions or interveners. And I mean, you know, this was filed on August 30, 2023, so we really haven't had a chance to talk about this. And I haven't addressed it in court, as you know. So, and we already started with the merits, okay, before I have approved the intervention. So my issue first is really on the standing, because the first round had something to do with the Constitution, state Constitution, U.S. Constitution, and I'm not sure that applies in this situation under Rule 45, and I think that the Supreme Court, the Idaho Supreme Court, sort of addressed that a little bit in the former motion for mandamus. So do you want to address that, the standing issue first?
Sure, Your Honor. With respect to the Supreme Court's decision, when we filed the petition in front of it back in January, I think they said that the media has the right and should be able to intervene when there are issues related to First Amendment issues and access issues. And Your Honor, I would submit that, and we understand that ICAR 45 is absolutely the governing piece of law on this. But when we talk about press access to the proceedings, cameras in the courtroom, I would submit, Your Honor, are part of that press access to the proceedings, because it's the cameras in the courtroom, it's the ability to have pool coverage, it's the ability to have still photographers that provide access to a much greater number of people than even having just the reporters who are going to write things down and post stories after the fact. It allows sort of that broader access that allows people to see sort of firsthand what is happening, and we think that's an important First Amendment right, Your Honor.
That's a First Amendment right, to have cameras in the courtroom?
No, Your Honor. Press access is absolutely, and public access, I think, is absolutely a First Amendment right.
So the press and the public have full access to this courtroom?
I agree, Your Honor. Having cameras in the courtroom, having still photographers, having live coverage allows that public access to be much greater than it is through just having people having to travel to Moscow, having to come into this particular courtroom, Your Honor.
That has no implication for the United States Constitution or the Idaho Constitution. I just want to clear this issue up in terms of what the standing is.
Your Honor, I respectfully disagree, because I think that the First Amendment and the Idaho Constitution both contemplate this right broad access piece of it. And I think there's an argument to be made that having cameras in the courtroom takes a step from that first right of public access and makes it more open to additional people. So I think there is a First Amendment interest there. It is certainly not as strong as, for example, if the proceedings, there was some sort of order to close the proceedings or no journalist could come into the courtroom. I think that would be a far more significant problem, Your Honor. But I think in terms of First Amendment interest, the broader, and maybe because there's some access already, the First Amendment interests are smaller, but I think there is a First Amendment interest in having broad access to the court proceedings. I think it's also in the interest of the court, Your Honor, to make that access as broad as possible, because we're unfortunately in a day and age where for some people, if you can't see it, you don't believe it, or if you can't see it, it didn't happen. And there's an increasing need for people to see for themselves precisely what's going on inside the courtrooms of this country.
Are there cases that support that?
That support cameras in the courtroom?
No. And that is based in constitutional law.
Well, Your Honor, I would say that the line of cases that we both cited, Estes in Chandler versus Florida, says that there's no prohibition on having cameras not in the courtroom. There is not a case that says flat out, under the First Amendment, there is a right to have cameras in the courtroom.
Okay. Well, I understand that. Let me, because I was looking back at this decision that the Idaho Supreme Court made, and it does say that petitioners, meaning you in that case, or your clients, I should say, are correct that Idaho's rules of criminal procedure do not provide a specific mechanism for third parties to intervene in a criminal case. Likewise, the federal rules of criminal procedure do not provide for a motion to intervene in a criminal case brought by the United States. Of course, you know that well. It says, however, both state and federal courts often permit the media to intervene in criminal cases on a limited basis, or at least file a motion as interested parties in the defense of public access and free speech, including in Idaho. So I think, we're on the same page on that, and I understand that. This idea of intervention specifically versus as an interested party, because I know in the Daybell case, the media was characterized as interested parties. I'm just not sure that we get all the way to intervention because historically anyway, my understanding of the rules is intervention means you are really a party in the case. And that gives you significantly more access. I'm thinking about this more as an amicus brief or presentation because I'm willing to hear it. I'm willing to read the briefs. I think that's important, but I'm not necessarily comfortable going to call it all, or the media coalition to be interventions. So do you see a difference there?
Your Honor, I understand the difference, the distinction that the court is making. That's why our motion to intervene has always been for a limited purpose. And you know, full candor, this was a difficult one to sort of try to solve procedurally. It's been my experience in Idaho state courts that rules and cases are read very literally, and we couldn't find a rule, so that's why we went to the Supreme Court to begin with, because there wasn't a rule that allowed us to do that. And I think for purposes of the proposed interveners, the media coalition in this case, that being allowed to present its argument to this court, whether it's as interveners for a very limited purpose, and that's without a rule, that's typically, I think, how you would get into a case. I was trying to liken this to like, you know, motion to quash a third-party subpoena, but there's a rule that allows you to come in and challenge that. So when there was no rule, we were trying to identify, well, what is the procedural mechanism? And intervention is typically, certainly there's a civil analog, and there's a way to, that's just the analog that we requested from the court before. We think it's consistent with what the Supreme Court said in the case that it decided in April. But if the court does not want to give us intervention status, I remember we had that discussion a little bit last time, and we asked you to sign the order, so in part that would be precedent for us to do this, and you did.
Yeah.
But
everybody agreed, so I signed it. But now I've thought more deeply about it.
Yeah, and I think, Your Honor, if the court would rather the media coalition appear as interested parties, I mean, that would also serve the media coalition, and we'd be happy to present argument just as interested parties so that there is some entity speaking for continued access in the courtroom.
Okay, and I could even label you as media coalition.
That would be fine with us, I think, Your Honor.
Okay, great. And there is some language, and I don't need to read it now, page 14 and page 15, that kind of caution going too far with intervention, or what we call it. And I'm trying to clarify this a little bit. I think the Supreme Court is trying to clarify it a bit in criminal cases. And my reading of this is they really don't want the media to just be coming into the middle of criminal cases to, I guess, exercise their concerns.
And I don't think the media wants to either, Your Honor. I think both with the initial motion to intervene and the issue that was raised last time about the non-dissemination order, and both this issue with respect to cameras in the courtroom, those were both about sort of fundamental access to the sources of information that this trial and this proceeding are really all about. And so that's, I think, the media doesn't want to have to, they don't have to pay me, Mr. Colon, every time they want to make an argument in court, and we don't think that would be appropriate either. It's just those issues that really fundamentally affect what sources of information they can access in the process of reporting on this floor, Your Honor.
Okay, great. Thank you, Ms. Olson.
Thank you, Your Honor.
I'll give you first. Mr. Rudley?
No. Well, Your Honor, the state has no objection to either classification of the media for the limited purpose of helping the court decide this issue.
Okay. Thank you, Mr. Rudley. Okay, Mr. Logston?
Judge, we're not going to object, obviously, to hearing from the media, and I certainly understand the court's concern, and it's interesting, but I mean, so long as I guess they're not filing things willy-nilly and making discovery requests, we're not terribly concerned about how they're being labeled.
Great, thank you. Maybe I'm just being a little nerdy about, the rules and, even the history in Idaho. And also relying on some of the language in the petition for writ of mandamus that the Supreme Court issued on, I guess it was April 24, 2023. So I really think it's more appropriate, and I looked into this to some level, and to serve an amicus brief, but not considered as a party, as an intervention, but sort of a presentation or brief addressing particular issues of interest that are important. No question about that. So that's how I'm going to view this, and I'm going to deny the motion to be for intervention. I don't know why I'm having a hard with that, but however, I will certainly consider the arguments, consider the briefs, and I will consider that while balancing the concerns of both the state and the defendant too. So let's move then to the arguments on cameras in the courtroom, and we'll start with Mr. Kohberger's team, and I believe that's also going to be you, Mr. Logsdon.
Yes, sir. Sure, I don't intend to take a lot of time. We've briefed this. Moreover, we somewhat argued it a few months back. I think our position is that the court, I think, understands our concerns about turning this into a spectacle, the way that may prejudice the public against our client, the way in which that dehumanizes people constantly shown. We turn this into more of a TV show drama than a court proceeding, which is what it is. And I think everyone understands that. Our concern is that since that time, it doesn't seem like much has changed. The media's argument, as far as I can understand it, is that the cameramen that are here are doing their jobs well. There are editors for various organizations, there are people on social media that take those images and then do things with them that we may not like. And that if the court removes the cameras, presumably those people will just use older images, and we won't have perfected things that will fall very far. Our position is that removal of the cameras does two things. One, it stops new images, and I don't think we can underestimate the power of novelty when it comes to what the public is interested in. Use of old pictures when it becomes ho-hum. There's a reason why we live in a world of memes where people are constantly trading around pictures. They quickly get old. There's a new one, it seems like every day. There's hundreds of brand new images. So the concept of removing this sort of almost sideshow from what's being put out there, we think would be an important way to kind of take away the sensationalization of this case and just kind of reduce it to hopefully the words on the page. And if they're using old photos, etc., we can't stop them. But we just don't see that as being as big an issue as a constant stream of new images that are being manipulated, etc., to make viral content or what have you. Our secondary point is just that we don't like where the camera is currently sitting because it looks like where I'm sitting and my laptop. I got one of these fun screens so that if you look at it from the side, you can't quite see what I'm doing anymore. But it's a distraction for us because we feel like essentially there's a camera right over our shoulder, and we certainly understand they're not zooming in on what we're doing. But I think we've already seen that once they make these images and they pass them around, I mean, well-made cameras, and somebody else could presumably do that. And so that causes us quite a bit of concern as well. So if the court decides that removal of the camera isn't necessary, we do have, I think, a bigger concern of just making sure that they're set someplace where we don't have images that are really just what we're working on during the case. And I don't really have much else for the court, unless the court has questions for me.
Well, I have one comment or question, because in one of your briefs, and I know I've had two sequences of briefs because we had this earlier, but this was a newer one where you were saying, well, this is a quote, were it only the kind of cameras used to show the workings on the House floor on C-SPAN.
I may be showing my age. They might have better cameras now, but when I was
I'm sure
younger, it was just this camera like way over there.
Yeah, well, that's the point. I mean, I made me think about that, is just plant a camera up there. If everybody can just see what's happening from the back of the courtroom, maybe that can satisfy everybody just partly.
That was kind of
That's
my
what you
idea, Judge.
suggested.
That was my suggestion. And I feel like somebody's going to throw a tomato at me, but that, I thought, might be a way to kind of give a little and just kind of protect what we're trying to protect.
I've never seen anything very sensational on C-SPAN.
And that's literally what I was thinking.
Yeah, that's
Although Newt Gingrich got pretty close to each other.
Yeah, there you go. Okay, well, thank you.
Thank you, Judge.
Okay, are we going to Mr. Rudley now? Yeah, no, Ms. Olson gets at the end of that, and then I'll go back to the parties. Go ahead.
Thank you, Your Honor. As we previously discussed, the decision of whether to allow cameras in the courtroom is discretionary for the court. The state outlined our concerns with allowing cameras in our responsive brief and in our June 6th briefing. Primarily, those concerns are preserving the right to a fair and impartial trial for all the parties, protecting sensitive witnesses who will testify at hearings and trial in this case, and safeguarding evidence, which is the graphic nature. We agree that the media plays an important role in the court process, and we appreciate in their briefing the measures that they identify to address some of our concerns for protecting vulnerable witnesses or evidence which is of a graphic nature that they've done in previous cases. However, our contention is that the safest way and best way to address all of these concerns is to prohibit cameras in the courtroom, or in the alternative, prohibit cameras when sensitive or vulnerable witnesses are testifying or there's evidence being viewed that's of a graphic nature. And I'll stand for questions.
Okay, thank you. Okay, Ms. Olson.
Thank you, Your Honor. And I think, legally, we're where we were 3 months ago with respect to what the rule the court has to consider in terms of whether to continue to allow cameras in the courtroom, and that's Idaho Court Administrative Rule 45. And I think, Your Honor, when we read through that rule, it really addresses the concerns that the parties have raised to this court about what the court's discretion is, about what it can, how it can direct cameras when they're to be in the courtroom, all of those things, that it can restrict camera coverage when there is a particularly sensitive witness. And I think, Your Honor, what you saw in the declarations that we submitted, the declaration of Rebecca Boone and the declaration of Grace Long, is that these are journalists who are experienced in covering court cases, and in covering court cases where there are cameras, both video cameras and still cameras, and following the court's admonitions about what can be covered and what can't be covered. And I think, particularly, Your Honor, with respect to Ms. Boone's declaration, and Ms. Boone, who is a graduate of the University of Idaho's journalism program, who continues to be an advisor to to that program and who certainly would have not only the best interests of her employer at heart, but she understands this community. I mean, her experience has been that when you have these pool cameras, both still and video, and when you allow camera coverage to the extent that you can, it better serves the public, and it helps ameliorate the kind of media scrum is probably not the term that my clients would want us to use, but the sort of that big gaggle of journalists who accumulate outside of a courtroom when there is no opportunity to be inside the courtroom, when you don't get the opportunity to have that full procedure. So I think the court can use Idaho Court Administrative Rule 45 and craft a solution that continues to allow the journalists who are working hard to cover this case to be able to do so in a way that both allows them to provide really a first-hand account of what's going on. And again, Your Honor, I don't think we can underestimate the importance of that first-hand video account as well, because we're just in this day and age where people are used to seeing things firsthand. There's cameras everywhere. To be able to really have great confidence in the proceedings, I think it's important for the court to allow some sort of in-courtroom camera coverage of the proceedings. People are going to need to be able to see firsthand for themselves how the evidence is presented, how they want to see the rulings that the court makes. They can learn a lot from that in a way that they can't learn from people who then are in the courtroom and they go set up outside and they talk about what happened. And so I think, Your Honor, that's a good reason to continue the policy that the court has had. And then I think, Your Honor, with all due respect to Mr. Lawson, I just don't think there are the violations of the things that the court said at the outset of the June 27th hearing. Now, I was not here. I read about it in the attachment that Mr. Lawson made to his initial, or the reference Mr. Lawson made to his initial pleading in this round. And my reading of that, Your Honor, it's actually in a Fox News story, is that the court said, and of course the court said it, so I'm sure the court's memory of it is the best, but that the court made a comment that the court should, of course I'm having a hard time.
Back up. That's one of the things I said.
Yeah, okay.
It was just focusing
Right.
too much in particular areas, and so I was just cautioning the media to step back, and they have pushed the envelope.
Yeah.
I'll tell you that.
Okay. Well, Your Honor, I think that what the media heard on that occasion, as reported by Fox News, was that the cameras needed to show a wide shot of the courtroom and not focus strictly on Mr. Kohberger. And I think that phrase, focus strictly on Mr. Kohberger, has clearly been interpreted to mean you can still take pictures of Mr. Kohberger, but he's not the only one you should be taking pictures of. And there's certainly a limitation in print media or the online stories. I mean, you don't always have video. So what I've seen, and I think the examples we provided to the court, where there were pictures of lots of different participants in the courtroom, and they're trying to show everybody. And if the direction from the court is instead, look, there can be no single pictures of Mr. Kohberger, the challenge is, and I think even Rule 45 says this, there are some limits on how much the court can tell the editors and everything, because they're not here in the courtroom, and some of those people may still choose to crop out just a little bit of that picture. And Your Honor, I don't think that runs afoul of what the court has in mind. I think that what you've seen is an attempt by the journalists who are here in court to show a wider shot. And then as we wrote in our brief, from that courtroom angle there, I mean, it's I think I said it's not a football field. It's hard to get sort of the full perspective when the camera is sitting right there. If there's a way to station the camera at the very back of the courtroom, maybe, but those are also the things, and you saw this in Ms. Wong's declaration, the court TV people have a lot of experience working with courts and trying to find the best way to both serve the purpose of having cameras in the courtroom and being able to present to the public the proceedings as they occur, and also not be obtrusive, not cause noise, not run afoul of the court's admonition to focus in on any particular individual. So they are more than willing to work with the court to do that. They just ask that he continue to be in the courtroom, because I think, Your Honor, when we look at the full media coverage, they haven't run afoul of that admonition. There are certainly still individual pictures of Mr. Kohberger, but that will continue to happen regardless, Your Honor.
Well, sure. I mean, in some ways, it kind of misses the point, because it's sensationalist sort of spectacle that is concerning, and from one of your, well, the declaration from TV or
Court TV.
Court TV. You know, I looked through, you know, all the cases that they filmed, and you know, some of those you could question whether that was a very dignified way to have a trial. And the classic is O.J. Simpson. So they're saying, oh, this is great. This is great work we did, you know, filming this. But if anybody watched any part of that case, it was a circus. So that is one of the concerns. In this particular case, we have a lot of interest, and we have a lot of people that you can't control, that your clients can't control, and they are putting out stuff that is harmful. It's harmful for the case, for this case, for the process to have a dignified trial. That's my worry, and that's my job. So when I have been talking to the media, just kind of, can you back off a little bit? Because I've been very accommodating, and I just start feeling like, can I really trust them to do the right thing? And it's not necessarily the camera people, okay? It's where that film goes, and how it is manipulated, and how people are, you know, commentators, how they talk about it, okay? How they explain it. And a lot of times it is not very accurate. And I don't watch all this stuff, but I've watched enough to see that how disinformation, misinformation is pumped out there, along with the images and with the films. So how do we deal with that? It's not the same media now than it was 10 years ago with social media, for example. I can't control that, you can't control that, I understand that. I mean, it's going to happen anyway. All I wish is that everybody had a little more respect for what we're doing here, because it's not entertainment. It's a tragic issue, okay? And that is what is disturbing to me, personally.
Your Honor, if I may, I understand all of that completely. I have been in Mr. Thompson's shoes in a very disturbing, heinous murder case with a lot of the pressures that go with that, and dealing with victims and victims' families. And that is a very challenging position to be in. And being able to, I think, Your Honor, having worked in the criminal justice system far longer than I've been in the position I'm in now, I think that in this media day and age, having cameras in the courtroom so that people can see what the proceedings are all about. And so there's at least a source out there that says, this is what happened. And if there was not that, that makes it much easier for the people who are going to disseminate disinformation, for the talking heads who aren't going to be respectful of the process to do that. Because then there's none of the actual footage from the trial that responsible media outlets and responsible consumers of information and responsible online people will be able to get access to. I think, Your Honor, the answer is not less sunshine, it's more. I don't think we can afford to abandon to whoever the guy on X or Twitter was that cut out a portion of one photograph of Mr. Kohberger, and then was glad that he got some call-out by Mr. Logsdon in his motion. I don't think we can afford to abandon how this case is portrayed visually to those individuals, Your Honor. And instead, frankly, of having pictures in the court, then you just get all the pictures of people going, in and out of the courthouse. But you're going to have the same content, Your Honor. The way to battle misinformation is to provide the accurate information, and the accurate information is what happens inside this courtroom with the cameras positioned in a place that provides the best, most overall perspective of the courtroom, and with if there are sensitive witnesses, then the court can give direction and the media will follow that you don't get to film those witnesses. The rule provides you don't get to film the jurors. There are all sorts of sensitivities built into ICAR 45, and the media would ask the court to use those tools rather than saying, no, we are not going to allow cameras in the courtroom, we're not going to allow video in the courtroom, because then you just don't get that accurate picture that they can portray out there. And Your Honor, I do think, with all due respect to the comments that Mr. Logsdon made in his reply brief, the members of the media who are in this coalition, who I think are covering this trial, who I think includes the news editor from the Daily Argonaut, from the student newspaper at the university, they are here because they think it's an important public service to cover the proceedings in a criminal matter of such importance to the university, to this community, and I think, Your Honor, really to the state of Idaho. And as I recall from my comments when we were here in June, I mean, this case has affected people all over the state. There are young people who were students at the university that I know who were affected by what happened. And having some ability to understand the proceedings and to get the closure will be important to them, Your Honor. And I think this court, this court accomplishes much more by allowing the cameras to stay in the courtroom and giving them firm guidance and working with them than it does to send them outside. If you want to see spectacle, I mean, see the 40 cameras set up outside of the courtroom, and every time someone walks out, they sort of get ganged up on. I mean, that, I think, Your Honor, is spectacle. With respect to the O.J. Simpson trial, which is, I think, one of the first sort of highly covered ones, I think the point of that one was to, like, look, you can have camera coverage of these cases, and the person, it's still possible for them to get acquitted. It's not prejudicial in terms of guilt or innocence to have cameras in the courtroom. But I think everybody learned a lot from that trial. It certainly didn't reflect well on poor Judge Ito. It didn't really reflect very well on the prosecutors. There are things that may have been playing to the camera because of that. But I think we all learned a lot from that, Your Honor. And hopefully, then changes can be made about where the cameras can be positioned. And there's part of it's the responsibility of the participants in the courtroom, not to adjust their behavior for the cameras. I don't see, Bill Thompson, the late Cobb County prosecutor, years and years and years adjusting his approach, or Mr. Nye, or the others who are working on this, because there are cameras in the courtroom. I know Ms. Massoff, I don't know these lawyers as well. I know Ms. Massoff is not going to adjust her performance in the courtroom, and she's going to do everything she can for that client, and I trust these lawyers will too, regardless of whether there are cameras in the courtroom. And I think, Your Honor, the public and this community will be best served by having those cameras in the courtroom and making sure that the guidelines that the court wants to put in place are there, and that there's this firm understanding by members of the media that they will follow that. And I just think it's just not true that things are met with the people who we represent, and the people who are in this courtroom today are here to make a spectacle of this proceeding. Thank you, Your Honor.
Thank you, Ms. Olson. So I just I hope I sent out a message to the media and everybody else that please have patience, be respectful, and be decent. That's what I want. So, thank you.
Thank you, Your Honor.
Okay, any response to any of that, Mr. Logsdon? You don't have to.
I guess not really sure where to go with that one, but obviously nobody's talking about throwing the media out of the courtroom or making the case go dark. I wouldn't want that. After all, I think the public definitely plays a very big role in making sure that we all do our jobs right. We're just talking about the images that are coming out of this. Sounds like the court, here's where we're coming from. I don't think I have a whole lot more to add to that. Thanks, Judge.
Thank you. Mr. Redley?
Nothing further, Your Honor.
Okay. Well, thank you all. I think it's a very interesting, really kind of powerful issue that is a benefit and also potentially a harm. And that there's a lot of balancing that will go into this consideration. Of course, I am especially sensitive to the parties of the case. I saw Mr. Thompson kind of smile a little bit about, there were in a lot of these cases where they were sensationalized and heavily filmed and talked about. The defendants were acquitted, and so therefore that proves that they got a fair trial. Well, we want trials to be balanced for both sides, and I don't know if I was reading your mind a little bit about that, Mr. Thompson, but it can tilt. It can tilt a case one way or the other if the media is, well, trying the case in the media. And we don't want that, because that's not based on evidence, that's not based on the rules of the court, and it can get out of control. And I think some of those cases that were cited in the declaration of Court TV personnel are kind of seeing it one way, and they have a certain job to do. I understand that, but some of those cases, in my opinion, kind of spun out of control, and that based on the media and how heavily it was covered. So that's my worry. I'm going to figure it out and try to do the right thing for both the public and the parties and the rule of law. So with that, we're adjourned.